Good day. My name is Mark Mellor. I'm an attorney with the Mellor Law Firm. I've got a number of clients in Yermo that are dealing with mechanics lien issues, so I thought it helpful to put together a quick video on some of the things you need to pay attention to when working with mechanics liens and California mechanics liens law. The first thing you need to pay attention to is who has the right to record a mechanics lien. And so who has the right to record a mechanics lien is the person who is in direct contractual privity with the owner, or the contractor in direct contractual privity with the owner. Now, there's an exception to that. If you're a subcontractor of a contractor, or a sub of a sub, or a material supplier, you have the right to record a mechanics lien too, but in order to do so, you must send certified mail return receipt requested a 20-day preliminary notice from within 20 days of the first time you mobilize on the project. And that will cover 20 days prior to the time that you mailed the work that you've done or the materials you've supplied to the project. That also puts the owner and lender and general contractor on notice that you're actually out at the project site performing work or supplying materials. It gives you the right to record a mechanics lien later on in the circumstance that you don't get paid. Now, assuming you've done that, or you're in direct contract with the owner of the property, then you can record a mechanics lien. How long do you have to record a mechanics lien? Well, I like to tell my clients that you've got 90 days from the last date you worked on the project to record the mechanics lien, 30 days if the owner of the project's already recorded what's called a notice of completion, the work's been completed. But in most circumstances, it's 90 days from the last work you did on the project. If you stopped working for 100 days and then came back out and did some finished work, or came back out and worked on the project again, then you have another 90 days from that period of time to cover all your work. Once you record the mechanics lien, however, your job's not done yet. You've got to then perfect the mechanics lien. So I like to tell a lot of my homeowner clients that come in all worried, hey, this contractor, he didn't do the proper work and he's recording a mechanics lien against my property. What do I do? I'm worried. I say, well, let's just hold on and wait him out, because the contractor, from the time they record the mechanics lien, has 90 days to file a lawsuit to perfect or foreclose on his mechanics lien. If he doesn't file that lawsuit within a 90-day period of time, the mechanics lien is no longer valid and can be expunged from the property record. There's a special motion in the Civil Code that allows for that process that we use all the time when contractors have blown the statute in terms of time frame to record their lawsuit. But nonetheless, you want to make sure that the lawsuit is filed within that 90-day period of time. If it is, the mechanics lien is perfected and it stays on the property. If not, it's no longer any good. So to recap, you just want to make sure that you're in direct contractual privity with the owner of the property. If you're a homeowner and you've got a contractor that's recorded a mechanics lien against your property, you want to make sure that they followed the statutory time frames from the last time they worked on your project to 90 days past the time of recording for the mechanics lien. Or if they're a subcontractor or a material supplier, you want to make sure that they sent you a 20-day preliminary notice by certified mail return receipt requested. If you have any other questions or particular circumstances in your project, please feel free to give me a call and set up an appointment. I'd be happy to discuss those with you.